Item 1 and 2, Himanshu Sinha, Dr. Saurabh Kumar Pandey, Ashutosh Pandey, with
May it please your lordship.
Mr. Srivastava, both these petitions are arising out of the common order.
Common order.
Yesterday, Mr. Sibbal has argued at length. Anything add you want to?
Yes, my lord. There are some points, my lord, which
Yes.
is left. Right? While me leaving, my lord, Mr. Sibal also said
Yes.
that you cover up these points.
Yes.
And just to save time, my lord, I have, my lord, prepared a bullet points, my lord. They are just taking a printout, my lord. I will
Yes.
give that, my lord.
Yes, yes.
Because there are few aspects, my lord, which needs to be, my lord, gone into detail, little bit. One thing, my lord, your lordship takes up, my lord, their application. Mr. Sibbal, my lord, my learned friend, my lord, he has already argued.
Yes.
And pointed out, my lord, that these petitioners, they have acquired, my lord, the citizenship of Vanuatu. Now, your lordship may just see, my lord, what is the statement, my lord, in the application, their application. Your lordship may take up the, my lord, matter of Ravi Uppal.
Page number?
It starts, my lord, from page 85. And your lordship may kindly come to, my lord, page 93, that is paragraph
Page 85 is execution of request. In my petition, in my file.
Paging ka difference hai kya? That is, my lord, annexure. Page 87, my lord.
87.
My sincere apologies.
Yes.
There appears to be, my lord, some difference in my page and your lordship.
There is no difference.
If your lordship comes to, my lord, paragraph 8.
Yes.
And then, my lord, in very short, my lord, I will give your lordship the points.
Paragraph 8.
Paragraph 8. Now, this is a statement made by the...
Paragraph 8 is at page number
95.
Yes.
95.
Yes.
And this is the statement, my lord, made by the ED for the purpose of seeking, my lord, a warrant of arrest.
Yesterday, Mr. Sibbal has already pointed out this part.
Yes.
That he was at Australia at that time.
Yes. But one line, my lord, which is very important here. And then I go to, my lord, my point.
Yes.
On 31/8/23, intelligence was gathered that Mr. Ravi Uppal and Mr. Saurabh Chandrakar have been detained in Australia. Accordingly, official email was written to Australian High Commission to confirm the same. A reply has been received from the Australian High Commission and it has been gathered. Now, your lordship may underline this, my lord. Mr. Ravi Uppal and Mr. Saurabh Chandrakar has obtained Vanuatu passport. This was not really, my lord, emphasized, my lord, on yesterday. They have obtained Vanuatu passport. They have obtained Australian visa on the basis of Vanuatu passport. Now, your lordship will see the table.
Yes.
Table, my lord, gives the detail that this is the Indian passport, and the second column they say they give the detail of, my lord, even the Vanuatu passport. Now, once they themselves say that we have obtained a Vanuatu passport, my lord, what is the, my lord, consequence thereof? And when a consequence arises, my lord, then they have to act, my lord, then on the basis of applicable laws. Your lordship may just see, my lord, Article 9 of the Constitution. The section
Yes.
What it says, my lord? The Article 5 and 6 are, my lord, and 8. Those are, my lord, the articles which shows how a person becomes an Indian citizen. One is, my lord, by birth. Second is, my lord, by naturalization. And third is by, my lord, migration from the erstwhile, my lord, area.
Yes.
That is, my lord, these are the three. That is, my lord, detailed in Article 5, 6 and 8. So, by virtue of this, my lord, somebody becomes, my lord, a citizen of the country. But what happens, my lord? Consequence under 9. Kindly, my lord, read along with me.
Yes.
No person shall be citizen of India by virtue of Article 5 or be deemed to be a citizen of India by virtue of Article 6, that is, my lord, because of the earlier areas. Or Article 8, if he has voluntarily acquired the citizenship of a foreign state.
Yes.
So what it says, my lord, that you are no more a citizen of India by virtue of Article 5, 6 or 8 if you have acquired the citizenship of another country. Now ED itself says that they have acquired the Vanuatu passport. So the Counts case has already ensued, that is that my citizenship has ceased. I am no more a citizen of India.
Yes.
Now, if I am not a citizen of India, then, my lord, what is, my lord, the next thing which is required to be considered by your lordship? And similar is the provision, my lord, under the, my lord, Citizenship Act, Indian Citizenship Act.
Just a minute. Just a minute. You, where is Mr. Saurabh Pandey?
He's coming.
Because neither Mr. Saurabh Pandey is there nor Mr. Joab Hussain is there.
Should I wait for 10-15 minutes? Because he is also entitled to hear, because he has to respond. Mr. Joab Hussain.
Yes, please. Yes, please. क्योंकि बाद में ये ना बोलें
कि हमने नहीं सुना. Now, your lordship may kindly have, my lord, section 9 of the, my lord, Indian Citizenship Act.
Yes. Yes.
Section 9(1).
Yes.
Any citizen of India who by naturalization, registration, otherwise voluntarily acquires or has at any time between 26 January 1950 and the commencement of this act voluntarily acquired. Pausing here for a moment, my lord. This deals with one who is already a citizen of India. That voluntarily acquired the citizenship of another country shall, upon such acquisition, this your lordship may kindly underline, shall upon such acquisition or as the case may be, such commencement cease to be citizen of India. So in much more clear terms, when the legislation or the parliament enacted this legislation, it made it more clear. The word cease to be citizen of India, that was not used in Article 9. But here it is clarified. Now, when the legislation says that upon happening of certain event, this is the consequence which will ensue, then citizenship goes by operation of law. This is your lordship, man.
No, what about 9(2)?
9(2), my lord, is this. If any question arises as to whether, when and how any citizen of India has acquired the citizenship of another country, it shall be determined by such authority in such manner and having regard to such rules of evidence as may be prescribed in this behalf. This is with regard to the, my lord, that if there is a dispute, I am saying that would be an entirely different purpose, my lord. When I am claiming citizenship, or I am saying that it is not, somebody is claiming that I am citizen, I am saying I am not citizen, or I say that I am a citizen, somebody says it is not a citizenship. So then question arises, my lord, with regard to question whether he is a citizen of India, then the authority who will decide it.
Now, in the present case, he is claiming that the Ravi Uppal is the citizen of India.
No, they are not claiming.
They have gathered information that he also acquired the passport of Vanuatu.
They are not saying in specific terms that I am a citizen of India. On the contrary, they are saying that I acquired the passport of Vanuatu.
Yes.
So law takes its own course. This is by operation of law. Nothing more is required to be done.
Yes.
So in this context, my lord, we have to see Now, if this is, my lord, the status of a person, whether he is an Indian citizen or he is a foreign citizen, then, my lord, in very short, my lord, what I will say is, my lord, your lordship may just see, my lord, Article 245 for a moment. These are the broad things your lordship will keep in mind, my lord.
Yes.
The source of power of, my lord, parliament and also the state legislature is, my lord, to make a law is under Article 245. Kindly, my lord, see with me what it says. Subject to provisions of this constitution, Parliament may make laws for the whole or any part of the territory of India, and the legislature of a state may make laws for the whole or any part of the state. Now, three things, my lord, which is to be noted in Article 245. My lord, there are judgments, my lord. I will just give the judgments, my lord, and paragraph. I will not consume your lordship's, my lord, time. The leading judgment was, my lord, in British Indian Navigation System, Supreme Court, where it says, my lord, that any law which is made by the parliament, it can operate only through the territory of India. Three things are said here, my lord, is this, that the parliament has power to make law, my lord, for the whole of the territory of India or even a part of the territory of India. That is the power of the parliament on both. So far as the state legislature is concerned, it has the power to make law only for the territory of their state. It cannot travel beyond that. The third thing which is very important is, my lord, the opening word. The opening word is subject to provisions of this constitution. So whenever law is to be seen, that has to be, my lord, seen in the context of, my lord, the provisions which are already provided, my lord, particularly for this case, as my learned friend, my lord, Mr. Kapil Sibal, my lord, the learned senior counsel argued yesterday. That if any of the constitutional provision, my lord, intervenes, then you cannot give a weightage, my lord, to the saying that no statute provides this. No. Then the constitutional provision will, my lord, that would be override. That will prevail. So these things, my lord, we have to keep in mind.
Yes.
My lord, Mr. Sibal yesterday therefore pointed out, section 59 and 63, two sections. What I want to add is here, this. Code of Criminal Procedure in, my lord, is a general law. It applies, my lord, to the all offences, my lord, which can be tried, my lord, under the Code of Criminal Procedure. But having enacted, my lord, a special law in 2002, that is the PMLA Act 2002. Then if any provision is made, my lord, under this act, then you have to go by the provisions which is already made under the special act. You cannot resort to the Code of Criminal Procedure. And Mr. Sibal has, my lord, already, my lord, pointed out, your lordship, my lord, what is the procedure?
Having overriding effect over
overriding effect. It is not the, my lord, matter of convenience of the investigating agency. Then whenever you find that I want to do something, if I don't find here, then I will do under some other law. No. Question is about the applicability of law. When there is a special legislation, then you have to go. Can I put it like this, my lord? How the ED get powers, my lord? They are the director, additional director, deputy director of a particular department. But how they get the power to do, my lord, these kind of investigation in a criminal matter? That is the prevention of money laundering. Because the statute gives them power. This particular statute gives them power. Now I am asking a question to myself, my lord. Can I say that I get the power from this statute? But when I want to act, I will ignore all other provisions, my lord, which regulate my power, which regulate my manner of, my lord, doing a particular thing.
So the powers given in the PML Act, in addition to or in derogation to?
It is, my lord, not in addition to, because it is specifically provided there. It is in derogation to. For whatever matter is, my lord, the provision has already been made under the PMLA Act. Otherwise, my lord, there would be conflict. If I put it, my lord, in another way, there is a general law which deals with, my lord, all the general offenses, but there is a special law. By making a special law, what is exactly being done, my lord? That the crime which relates to, my lord, the money laundering, that is carved out from the, my lord, general law, and for those carved out cases, a special law is, my lord, brought into force. Then the general law cannot be resorted to.
Yes.
प्रिंटआउट भी निकल गई सब सर दोनों जजमेंट I will put it, my lord, in another way. Yeah. My lord, this is a settled law, my lord. The time and again Supreme Court has said the citation. Your lordship may just have, my lord, I will be reading only one paragraph. The citation 368. This is, my lord, citation is 2005, volume 1, SCC 368.
2005, volume 1.
SCC, page 368. The relevant paragraph, your lordship will find is paragraph 26. At page 378. Your lordship will find it, my lord, at page 378. What Supreme Court says, my lord? Whenever the statute prescribes...
Yesterday, Mr. Sibal has pointed out this para 26.
No, this is not. This was not. Whenever the statute prescribes that a particular act is to be done in a particular manner.
Yesterday he has referred this, para 26.
So what it says, my lord, is this. If something is already prescribed
it to be done in a particular manner, that has to be done in that particular manner.
Or it is not at all to be done. This is what the Supreme Court says. Whenever the statute prescribes that a particular act is to be done in a particular manner and also lays down the failure to comply with the said requirement leads to the severe consequences, such requirement would be mandatory. It is the cardinal rule of interpretation that where a statute provides that a particular thing should be done, it should be done in the manner prescribed, and this is, my lord, not in any other way. It is also settled rule of interpretation that where a statute is penal in character, it must be strictly construed and followed. Since the requirement in the instant case for the obtaining prior permission, that is not relevant, my lord. So what the Supreme Court says, what I am, my lord, adding is this. Either you do it in the manner in which it is prescribed, or you can't do it. Then it totally goes. Not only the Supreme Court says that do it in a particular manner, Supreme Court says that there is a bar, that you can't do it in any other manner. There is another judgment on this point, that is 2021, volume 6 SCC, page is, my lord, 707, paragraph is, my lord, 14. And here, my lord, they have relied upon, my lord, another earlier judgment, my lord.
Yes.
If your lordship comes to your paragraph 14, and they have quoted below paragraph 17 of that judgment. This court has time and again emphasized that if a statute provides for a thing to be done in a particular manner, then it has to be done in that manner alone and in no other manner. Among others, in the matter relating to the presentation of the election petition, etc., etc. Then paragraph 17, which is quoted, my lord, from Mahavir Prasad's case, my lord, is this. It is well settled, is salutary principle that if a statute provides for a thing to be done in a particular manner, then it has to be done in that manner and in no other manner. Therefore, it is a salutary principle to keep in perspective. In the instant case, though the authorized officer is vested with the sufficient power, such power is circumscribed by the procedure laid down under the statute. This is very important, my lord. This is what, my lord, I am trying to canvass. That the ED cannot say that my source of power is the PMLA Act, but I am not bound to follow the procedure laid down in therein. As such, the power to be exercised in that manner alone, failing which it would be fall out of the requirement of the complying with the due process under law. Then everything falls, my lord, if it is not done in that manner. Now, what my Mr. Sibal has already argued, my lord, I adopt that also. But and your lordship may kindly come to, my lord, section 59 again, my lord. Yeah. And then I will give, my lord, without admitting, my lord, I will give, my lord, my alternate argument also. Yes. Reciprocal arrangement for process and assistance for transfer of accused persons. This has been pointed out by Mr. Sibal, my lord. Where a special court in relation to an offence punishable under section 4 desires that one is, my lord, summons. We are dealing, my lord, first with the summons which was issued under section 50. Then your lordship may kindly see, my lord, what is the procedure. After D, it reads like this. Issued by it shall be served or executed at any place in any contracting state. It shall send such summons or warrants in duplicate in such form to such court. Your lordship may kindly underline, my lord, this. I will explain why these words are used. To such court, judge or magistrate through such authorities as the central government may by notification specify in this behalf, and that court, judge or magistrate, as the case may be, shall cause the same to be executed. What I want to add is this, my lord. While enacting this statute, my lord, why the parliament mentioned the word judge, court or magistrate? You are still at the stage of issuing summons and serving it. Only at this stage. But despite that, why the parliament uses the word judge, court or magistrate? Why why it has not used the, my lord, any similar authority, my lord, like, my lord, the director or, my lord, police officer or any other authority? There is a purpose. And your lordship knows, my lord, right from 1952, my lord, the Supreme Court is saying that none of the provision, my lord, either under the statute or under the rules or, my lord, even the guidelines is without any purpose. First, the lawmakers, my lord, they conceive the purpose first. After the purpose, they, my lord, conceive that it needs to be done. And to achieve that purpose, my lord, they make the law. So every provision has a purpose. So what was the purpose here? Purpose, kindly go back, my lord, to my argument, Article 245. Because the parliament knows it is making law, my lord, every day. It knows that my power of the parliament is only to make law within the territory of the India. It can operate only within the territory of India. Therefore, when you ask to do something in a foreign court, then in a foreign territory, then in a foreign territory it must be tested. Therefore, it is, my lord, there is a purpose is this, that it will go to a court so that it can examine whether it is required or not. Therefore, it is sent to the court. Because if it is sent to an authority, my lord, it will just act on the basis of this, my lord. That yeah, there is a requisition, it asks me to do something, and I will do it.
Yes.
That is not the intention of, my lord, the parliament. Keeping in view that you are dealing with a foreigner, you are trying to either take action or you are asking to do something or to a foreigner. Therefore, it must be tested in a foreign court also. And as Mr. Sibal rightly said, then the next step would be after the court examines it, then it will cause it to be executed.
Yes.
And if this is the provision, my lord, then the circular which has been, my lord, shown to your lordship, my lord, yesterday, framed under 105. This is, my lord, the language. If your lordship sees, my lord, this language, which is, my lord, in subsection 1, the part I have read out, it is almost pari materia with the, my lord, provisions, which is, my lord, in subsection 105B, subsection 2, CRPC.
Yes.
So the procedure here could be only with this. You cannot apply to the court for issuance of warrant here because you want somebody who is beyond the territory of India, you want to serve him. Procedure would be that you make a request to the Ministry of Home Affairs under the circular, and very importantly, my lord, Ministry of Home Affairs will not, my lord, act on that request. The circular says that it will examine. That is, my lord, page P8.
Page
80. '81 would be the relevant portion, my lord.
Yes.
But Mr. Sibal has already pointed out that it applies to summons, warrants, and judicial process, all the three. That is mentioned in paragraph 2.
Yes.
If your lordship turns to, my lord, the next page, 82. If I can read, my lord, the whole of paragraph 3,
yes,
it would be important. What it says, based upon experience gained, some guidelines are given below, which may be followed while making a request to MHA for service of judicial process. It may, however, be noted that it is a discretion of the requested country to serve the documents at the time frame for a positive response cannot be predicted. Then A, all requests for service of summons. Your lordship may kindly underline this, not summons. Note says judicial process, we are concerned with the summons. On person residing abroad shall be addressed to the Under Secretary Legal, IS2 Division, Ministry of Home Affairs, 9th. Then what is required to be given below with the following information? A, material facts of the criminal matter, including purpose of the request and the nature of assistance sought. The offences alleged to have been committed, a copy of the applicable laws and maximum penalties for these offences. These are the requirement. Then kindly turn to below next page. Name, designation, telephone and fax number of the person, officer who will be able to give any clarification. So MHA can ask for clarification on the request. The complete address of the issuing authority to which the judicial paper service reports may be returned. So why it says returned? That after examining the matter, the MHA may say, no, we don't accede to your request. Therefore, we return it. Approval of the competent authority to bear any expenditure which may be charged by the foreign government agency for the service of the documents. G, at any time limit within which the request should be executed. Then most important, will not kindly come to B. MHA on receipt of request will examine it in view of the provisions of the treaty if exist with the requested country and as per the provisions of the CRPC in case of non-treaty countries. Now, my lord, by Mr. Sibbal, my lord, learned friend has already, my lord, pointed out that this itself makes a declaration that there is a treaty with UAE. So what is required to be done? That Ministry of Home Affairs is now at
Just a
this stage will
clarification, my lord,
examine.
please. Just for my own knowledge, a clarification. Is he a UAE citizen? Because I was given to believe otherwise. Just a clarification.
I think you hear the whole argument, everything will be clear to you. If not clear, then I will give it in a rejoinder. MHA on receipt of request will examine it in view of the provisions of the treaty it exists with the requested country and as per the provisions of the CRPC in case of non-treaty. So what is required to be examined? One, what is your request? Two, you are asking to serve the summons for which what is the material? Three, whether those materials are sufficient. Then four, this will answer my learned friends' question. Four, whether there is any treaty. I am just answering it, my lord. If they find that there is no treaty, then they will examine it in under the provisions of CRPC. So whether I am a citizen of UAE or I am a citizen of Vanuatu makes no difference. Because it only makes this, that if there is a treaty, then it will be examined whether the treaty covers this kind of request or not. If there is no treaty, then it will be provisions in the context of the CRPC. Then it will be, my lord, the application of mind. And thereafter only, my lord, it can send, my lord, the request, my lord, to the other country. Kindly see, my lord, D. MHA requires at least a period of 12 weeks time for service of such notice in the concerned countries. My lord, this is very, very important, my lord, for another point. They issued a summons on 1st, asked to appear on 2nd. I am not going on to that aspect, my lord, which my learned friend has already argued. How it is possible if somebody is abroad. 2nd, they issued on 2nd and asked me to appear on 4th. Now consider it in the light of this, my lord. If a person is in abroad, my lord, after the decision is taken by the Ministry of Home Affairs, 12 weeks time, my lord, to service. And therefore, Mr. Sibbal rightly said that this notice was nothing, it was farce. The second point your lordship will note is this. By not adopting this procedure, they have not only violated the law, but they have taken, my lord, right of the MHMA, Ministry of Home Affairs, to examine the matter before, my lord, a notice is sent. They have denied this right, my lord, to MHA, under whom they work.
Yes.
So there is another violation, my lord. So Mr. Sibbal rightly said that this notice is nothing, this is farce, total farce. And after this, my lord, it goes, my lord, to the court of the country where the person is there, which I have already argued, my lord. After this, my lord, that court will examine whether to act upon this request or not to act upon that request. So, next stage, application of mind by the court of that country, that is also, my lord, taken away.
Yes.
So this I wanted, my lord, to add, my lord, on the PMLA Act. Now, my lord, for the purpose of, it's my duty, my lord, to clarify the legal position, my lord, to your lordship,
Yes.
my lord. Otherwise, my lord, maybe it's an important matter, not only for me, my lord, it may be important matter for ED also.
Definitely.
Now, I am not admitting, my lord, the Code of Criminal Procedure applies. This is, my lord, not at all, my lord, my submission. But assuming for a moment, my lord, I can't say, my lord, I can only argue before, I can make my only submissions. What decision will be taken, my lord, that is your lordship's prerogative.
You already made a disclaimer that I am not admitting.
So, it's my duty, my lord, to
Yes.
make an alternate argument.
Yes.
Suppose, my lord, and after, my lord, all this, after considering your lordship, my lord, ultimately comes to the conclusion, no Code of Criminal Procedure, thousands of Code of Criminal Procedure will apply. Then what would be the situation? Now, kindly take up, my lord, please, Code of Criminal Procedure. And again, for this purpose also, my lord, I would be relying on those two judgments only.
Yes.
That if anything is to be done in the manner prescribed, otherwise not. There are two separate chapters, my lord.
Yes.
One is chapter 6 of the Code of Criminal Procedure, starting from section 61.
Yes.
Starting from section 61. Section 70, 73 is, my lord, part of the, my lord, chapter 6. I will come to this, my lord, later, my lord. Even on this, on my alternative side, what could be done, what could not be done. But there is another chapter, my lord, that is 7A, which starts from, my lord, section 105A.
Yes.
And if lordship, my lord, just see, my lord, at the bottom, this was by a, my lord, an act, this was added by an act of parliament, my lord. The act number is, my lord, 40 of 1993, with effect from, my lord, 20th of, my lord, August 1994.
20th of July 94.
July 1994. So this was added, my lord, by, my lord, an act of the parliament. Now, when this was added, my lord, whether, again I am saying, my lord, then again it's special legislation and general legislation. Kindly see, my lord, here, my lord, non-definition provision is already there, my lord, in the Code of Criminal Procedure. But here, my lord, another, my lord, definition provision. Your lordship knows, my lord, when there is an amendment to the act, my lord, the provision is added. But if a provision is added, my lord, with a definition, then it would be, my lord, a self-contained code, especially for that purpose. Kindly see, my lord, two sections here. Definitions. 105A, clause A. Contracting state. Means any country or place outside India in respect of which the arrangements have been made by the central government with the government of such country through a treaty or otherwise. And then kindly see, my lord, the definition C. Proceed of crime. Means any property derived or obtained directly or indirectly by any person as a result of criminal activity, including crime involving currency transfers or value of such property. when this amendment is made, my lord, in 1994, by that time, my lord, PMLA Act has not come into force. Our argument stands there, my lord, that it will be only under the, my lord, PMLA Act and the procedure prescribed under the PMLA Act. But even before the PMLA Act came into force, my lord, there was a special provision made, so as to, my lord, deal with the, my lord, person, one, that he is in a contracting state abroad, and two, in relation to, my lord, a crime which is a, my lord, relating to proceed of crime. A special provision was already made. So, as soon as this special provision is brought into force in 1994, the application of Chapter 6 goes within the statute, this being the later law, also special law. Why I say special law? Because it is dealing with a specified kind of cases. A special law within the statute, this will prevail. Chapter 6 goes. Now kindly see, my lord, section 105B2. This was not read over to your lordship yesterday. Notwithstanding anything contained in this code. So it starts with a non-obscenity clause. Your lordship knows, my lord, whenever a provision starts with a non-obscenity clause, it overrides everything in the code. In the course of an investigation or inquiry, this includes investigation into an offense, an application is made by the investigating officer or any officer superior in the rank of the investigating officer that the attendance of a person who is in any place, kindly underline this word, who is any place in a contracting state is required in connection with such investigation or inquiry, and the court is satisfied. Kindly underline this word. That such attendance is so required, it shall issue a summons or warrant in duplicate against the said persons to, kindly underline why I was saying, my lord, why actually, my lord, this is incorporated in the PMLA Act. To such court, judge or magistrate, exactly the same line. In such form as the central government may by notification specify in this behalf to cause the same to be served or executed. So 105B2 will apply.
Yes.
And if 105B2 applies, then the procedure is to be followed. And procedure is already laid down. It says, my lord, in the manner central government. That is already there, your lordship. I have shown to your lordship.
That would notification. Yes.
Your Lordship knows, my lord, that something which cannot be done directly, it cannot be done indirectly.
Yeah. The 2005 judgment and 2003.
Number of judgments.
Yes.
Now, without admitting again, my lord, they rely, my lord, under chapter 6. They made applications on 70. So it's my duty, my lord, to point out, even if, my lord, that applies, what would be the legal position. Kindly come to, my lord, section 70 and then 73. First, that your lord, Mr. Sibal has already pointed out, it is with regard to only process. There is no source of power under 70 to issue a, my lord, warrant.
It is
or
only a
process.
form of warrant.
It is a full form. But I will go, my lord, I will take everything in favor of the ED. Your lordship knows, my lord, the mentioning of a wrong provision is, my lord, not a crime. But whenever the statutory authority is acting, or even the court is acting, they want to do something. Many cases are, my lord, filed before lordship. It comes up before lordship. Somebody says that I want this relief. And many times your lordship says, yes. But under what provision? You tell me under what provision I have this power. Even the High Court and Supreme Court ask this question. I may give you, but you tell us what is of my power. I have to satisfy first about my power that I can do it. In that context, my lord, the special court was required to see that where is its power, where the power lies. The court cannot, without seeing what the section 70 is, can just proceed, my lord, to pass an order. The recent judgment of the Supreme Court, you cannot become a post office of the CBI or of the investigating agency. Number of judgments. You cannot pass an order, particularly, my lord, an order which is, my lord, relating to somebody's personal liberty, mere for asking. You have to be satisfied about your own power, what you can do and what you cannot do. Then at least the session judge should have seen section 73.
Yes.
And assuming, my lord, that they could have invoked the power under 73, then what is the test laid down under 73, my lord? Kindly see. The Chief Judicial Magistrate or a magistrate of the first class may direct a warrant to any person within his local jurisdiction for the arrest of any escaped convict. Kindly underline, my lord. Arrest of a escaped convict. That is not their case. Proclaimed offender. Till date, I am not proclaimed as an offender. Or of any person who is accused of a non-bailable offense, and it uses the word and, is evading arrest. So at the most, they could have invoked this on the ground that he is evading arrest. Kindly, my lord, bear with me, my lord, and kindly go again back to their application. Page batana. Page 88 is the application, my lord.
Yes.
And if you, my lord, from paragraph 1 to, my lord, 9, not one word, one sentence that I am evading arrest. There is a statement in paragraph 10 which is just contrary to it, my lord. Kindly see, my lord, this. And their application should have fall, my lord, should fall only on this. Paragraph 10, my lord, at page 97. What they say.
Yes.
And the learned judge, my lord, doesn't even care to, my lord, see this. That Mr. Saurabh Chandrakar and Mr. Ravi Uppal have deliberately been evading investigation. The ground under 73 is evading arrest. How could they even make this application, my lord, before the court on this? And to say, my lord, that somebody is evading arrest, what is required to be shown? They are required to show and make a statement that X person was required. Second, the X person was required for the purpose of arrest. Third, this is how we tried to arrest him. Then fourth, our effort failed despite our best efforts. Then fifth, you can say that he is evading arrest. Without saying 1, 2, 3, 4, you can't even say that he is evading arrest. And here they don't say that they are evading arrest. Just trying to show, Your Lordship, Lord, how mechanically the things have been done.
Their application has been filed on 4th.
This is what, my lord, yesterday, in fact, I tried to, my lord, explain this. ED shows summons, my lord, on 1st, for 2nd. They issue for 2nd summons, 2nd for 4th. So they have to wait up to 4th. 4th application is made. The time has not expired, they make an application.
Showing that they are evading arrest.
Investigation.
Evading the investigation.
Investigation. Where, my lord, was it not a premature application? If you have asked him to appear on 4th, you have to wait for 4th. Earliest you can file an application is 5th. According to my information, my lord, this application was filed, my lord, at 11 a.m. And the same day, my lord, the order is passed. Order is also a 4th. And judge doesn't, my lord, apply his mind to all these aspects. And that's why my learned friend was yesterday saying that it was only a design. It was a farce.
Yes.
Another thing your lordship may see, my lord, in this. A statement which is made in application. I am, my lord, pointing out everything from the application. Apart from application, I am not bringing any other fact, my lord. Kindly see what is the statement made, my lord, in the application. Kindly come to, my lord, paragraph 93, page 93. This was read out to your lordship yesterday by Mr. Sabbil, last 3 lines. The main accused, namely Mr. Saurabh Chandrakar, Mr. Ravi Uppal, who are sitting abroad, are out of reach of Indian law enforcement agencies. This is the statement made. Having said so, they don't say that they are out of reach of ED. They say that the Indian law enforcement agencies, that would include every enforcement agency. Having said so, could they apply? And could they ask for a relief which is asked for it here. Kindly say, my lord. Mr. Sibal has said, my lord, that it is contrary to the, my lord, rules provision. But what I want to say, my lord, on facts also. Prayer 2, my lord, page 98. The non-bailable warrant so issued may please be directed to be executed through the officers of the Directorate of Enforcement. What is this, my lord? You say in your application that they are out of reach of law enforcement agencies. Then why you are asking for a warrant to execute it? If you are not in a position to execute it, how the warrant is going to help you when you say that they are out of your reach? Not only your reach, but the out of the reach of the every law enforcement agencies in India. Why you are asking for this warrant? Are they trying to say that we want to have only one paper, which may be just a scrap paper, but we want to have a scrap paper? They are before the court of law. They are approaching a special court. So some kind of seriousness has to be shown by them also while making an application. Not that one officer thinks that, no, I want to do this, and he goes to the court. There has to be reasonability and proportionality in every action of the statutory authority. You may not expect this reasonability and proportionality from every person. There are different kind of persons available in the society. But at least for a statutory authority, a reasonability and proportionality is expected. This is what I am trying to say, Virat. Now I go, my lord, I put it, my lord, in the reverse direction, my lord, now. For making this application, my lord, what is the cause of action? Cause of action is that we issued a summons. That summons is not honored. Therefore, issue a warrant of arrest. So if I seize, my lord, on the reverse direction, then the court has to first see whether there is a valid summons. Then only its question of, my lord, its honor or dishonor will come. If the summons itself is invalid, everything will fall. The court will always say, no, I refuse to pass an order because your summons is not valid. You are asking me to exercise my jurisdiction on the footings of that summons. That is your basis. And if basis goes, I refuse to pass this order, I refuse to exercise my jurisdiction. And what the learned judge says, my lord, is this. My lord, I will cite the judgment, my lord, later.
Yes.
One point I have already, my lord, covered. The second thing, ऑर्डर पार्ट देने जरा, that is Milord P1 starts Milord from page आपका आप 42 पेज 40 Milord.
Yes.
Because we have challenged it Milord on the ground of non-application of bind also. तर्क श्रवण किए गए। केस फाइल के अवलोकन के संक्षेप में मामला इस अभियोग के प्रकार है कि मोहन नालत स्वर्ण राजपूत रामप्रेस साहू खड़क सिंह राजा सिंह के विरुद्ध सट्टाबाजी लूटे फुटबॉल एवं गेम खेलने के हेतु ऑनलाइन माध्यम से खिलाए जाने के कारण प्रथम सूचना अपराध स्वर्ण सो आईटी एक्ट के अंत उपयोग पत्र न्यायालय मजिस्ट्रेट के श्रेणी दुर्ग के समक्ष प्रस्तुत किया गया है। उक्त अधिसूचित अपराध के आधार पर प्रवर्तन निषेधालय क्षेत्रीय कार्यालय रायपुर के द्वारा जांच प्रारंभ कर ईसीआई नंबर 1600 अंतर्गत धारा 3 एवं 4 दंड शोधन निवारण अधिनियम के अंतर्गत पंजीबद्ध किया गया और जांच अन्वेषण में प्रथम दृष्टया अपराध पाए जाने पर सतीश चंद्राकर, चंद्रपुर वर्मा, अनिल दमानी, सुनील दमानी के विरुद्ध कार्रवाई करते हुए गिरफ्तार किया गया है तथा वर्तमान में वे न्यायिक अभिरक्षा में है तथा जांच के दौरान लेबल किए गए साक्षियों के पास धारा 50 के कथनों के आधार पर यह पाया कि प्रस्तावित अभियुक्त सौरभ चंद्राकर एवं रवि उपल जो भिलाई जिला दुर्ग के निवासी उनके द्वारा महादेव बुक ऑनलाइन ऐप के माध्यम से सट्टा एवं बाजी के दो लोगों को ऑनलाइन खेल खेलने हेतु उत्प्रेरित कर उनके माध्यम से अपराधों के आगम अर्जित कर लगभग 600 करोड़ की अधिक संपत्ति निष्कलंक संपत्ति के रूप में प्रदर्शित कर धन शोधन का अपराध कारित किया है, जिसके संबंध में ये लॉर्डशिप में जस्ट अंडरलाइन दिस अभियुक्त को दिनांक 1/9/2023 एवं 2/9/2023 को उनके धारा 50 के तहत कथन लेखबद्ध किए जाने हेतु विधिवत सम्मत जारी किया गया था, परंतु उक्त अभियुक्त गण अपने निवास स्थान एवं व्यावसायिक स्थल निरीक्षण पर उपस्थित नहीं होने के कारण उनके निवास स्थान में विधिवत सम्मत चस्पा कर तामील कराया गया। उसके पश्चात भी तिथि पर के जांच एवं अन्वेषण की कार्रवाई में सहयोग न करते हुए कार्यालय में उपस्थित नहीं हुए हैं, न ही अपनी अनुपस्थिति और सहयोग के किए जाने हेतु कोई पत्राचार एवं जानकारी कार्यालय को प्रस्तुत कर की तथा वर्तमान में ये जांच एवं कार्रवाई में सहयोग नहीं कर फरार है। ये फरार होने का तो एलिगेशन ही नहीं, एप्लीकेशन डजंट से दैट दे आर एब्सकॉन्डिंग। अन्वेषण में कार्यवाही की आवश्यकता है तथा जानकारी के अनुसार वे भारत से बाहर होकर, काइंडली अंडरलाइन दिस लॉर्ड, होकर अपने आप को छिपा रहे हैं और कार्यवाही के से बचने का प्रयास कर रहे हैं। सो दीज टू थिंग्स लॉर्ड, फरार है मींस एब्सकॉन्डिंग, बाहर रह करके अपने आप को छिपाने का प्रयास कर रहे हैं मींस दे आर कंसीलिंग देमसेल्व्स, दैट इज नॉट पार्ट ऑफ एप्लीकेशन। विचार किया गया अभियुक्त प्रकरण के तथ्य परिस्थिति तथा अभिलेख के उपदस्तावेजों के आधार पर आवेदन पत्र स्वीकार कर अभियुक्त सो के खिलाफ गैर जमानती वारंट जारी किया जाए। इज इट मे नॉट द कंसिडरेशन, is it the consideration of without relevant law, relevant facts, or it is just mechanical man? फरारी का और कंसीलमेंट का ये तो एप्लीकेशन ही नहीं है। वेयर फ्रॉम ही इज गेटिंग इट? Then in the same page, my lord, your lordship may see, my lord, two words which are very important. At the first line, के पास 50 के कथनों के आधार पर यह पाया कि प्रस्तावित अभियुक्त, काइंडली अंडरलाइन दिस, my lord, प्रस्तावित अभियुक्त। What 73 says? That he is an accused. when the ED says or the court says he is only proposed accused, means that you are still at the stage of investigation, you are trying to collect material, etc. And your lordship needs to learn that the investigation is for the purpose of finding out the truth. And the result may be either side. After that, you can say, no, not sufficient material is not available, therefore there is no ground to proceed.
Yes.
Conversely, after the material is received, you can find out that the sufficient material is available, therefore it's a fit case to proceed. So at that time, he is not an accused. 73 says he is accused of a cognizable offense. And then second requirement that he is a Vidiger. Having said so that he is only a proposed accused, should have rejected at that stage only. The power can't be excised. And what the line says, my lord, consider it from another aspect. What is the notice? Notice is section 50 notice. What is the purpose of that notice? Only two. Either to give evidence or to submit documents, produce documents. So in either cases, my lord, status of the person who is noticed is of a witness. ED cannot split, my lord, or merge the identity that for the purpose of issuing notice, you are a witness. But if you fail, you are accused. A witness, if he doesn't respond to notice, he doesn't become an accused. He may be liable for the consequences which is otherwise provided in the statute for defying a notice. But his identity doesn't change to an identity of the accused. He is still a witness. I'm just giving an example. In a trial, two persons are prosecuted. They are charged. They are facing the trial for the conviction. But there are 10 witnesses. One witness is issued a summons to appear and give evidence. He refuses to obey that summons. Provision that he can be brought before the court. Then there is a fine also. Even after imposition of that fine, he doesn't become an accused of that trial. He doesn't become a co-accused along with those others because you failed to respond to the notice. So his status is still of a witness. And if he has failed, my lord, as a witness, can you invoke 73? 73 speaks about, my lord, only an accused of a non-cognizable offense. So my alternate argument is this, my lord, taken worse scenario. Even if you want to invoke provisions of, my lord, chapter 6 of the, my lord, Code of Criminal Procedure, you have no case at all. And at least the session code, which is the, my lord, court of session, with a sufficient experience, he should have kept all these things in mind before passing an order. Because ultimately that order, my lord, that relates to, my lord, somebody's personal liberty, which is protected, my lord, under Article 21. Time and again, Supreme Court is saying, if you are dealing with the personal liberty of somebody, then you have to be very, very cautious about exercise of your power. All these laws have to be kept in mind, my lord. These laws which are, my lord, the judgment which are pronounced by the, my lord, High Court and Supreme Court, it is to be followed by everybody. Not that we argue this only before the High Court and Supreme Court. That you are bound by your law, but nobody else is bound by. Mr. Sibal has already pointed out, my lord, that the parliament has already taken care of this situation. The notice is issued under section 50, summons is issued, and the consequence is under 63. That is fine. Then how you import chapter 6 of the Code of Criminal Procedure? Now, why I say, Lord, that the notice itself was, Lord, bad for another reason. The reply says, we have taken a ground. How could you affix this, Lord, at the last known address, Lord, in India, and at the residence, when you know that the person is abroad? The reply, Lord, that says that under 65 they can do it. That is again chapter 6. So my main argument is, Lord, section 6, chapter 6 doesn't apply at all. But assuming for a moment it applies, then the 65 will come into play only when there is a failure. Kindly see, Lord, 61 to 64. Nobody can jump like this, Lord, saying that I straightway go to 65. Mm. 62, my lord, first. Every summons shall be served by a police officer or subject to such rules as the state government may make in this behalf by an officer of the court issuing it or public servant. Then subsection 2. The summons shall, if practicable, be served personally on the person summoned by delivering or tendering to him one of the duplicates of the summons. So even CRPC says when summons are to be served, it has to be served on the person by delivering him personally the copy, one of the copies of the summons. Then kindly see, Lord, 63. Service of a summons on a corporation may be affected by serving it on the secretary, local manager, or the principal officer. So this is with regard to the, Lord, the companies, etc., and corporations. 64. Where a person summoned cannot, by exercise of due diligence, kindly underline, Lord, this, due diligence, be found, the summons may be served by leaving one of the duplicates for him with some adult male member of his family residing with him. Now, there are two things, my lord, here. This is alternate mode of service when it can't be served, my lord, under 62(2). This alternate mode will come into play when the person to whom you want to serve cannot be found. The key word is, my lord, the found. After due diligence. What is the meaning of, my lord, word found? Means you don't know where he is. You don't know about his whereabouts. Then you say that the person can't be found. If you know that the person is sitting here or there or residing somewhere, then he is found. These are two different things to say that he is not found here, but he is found there. But in any case, he is found. What their application says? On 31st, they gathered information that they are detained in Australia. So person is found. (64) doesn't apply. Now how 65 reads, my lord? If service cannot be exercised of due diligence be affected as provided in section 62, 63 or 64, the serving officer shall affix one of the duplicates of the summons to some conspicuous part of the house of the so and such person. House 65, my lord, can come into play unless and until, my lord, there is a failure under 62 and 64. Before resorting, my lord, to affixing this, my lord, they have to consider 62 and 64. And this particular case, having said that they are found in Australia, they cannot even resort, my lord, to 65. Then maybe a cumbersome process, but they have to abide by law. They know the whereabouts of the person. Then they have to fall back, my lord, either to 105(b)(2) or they have to fall back under 59(1) and then adopt the procedure to serve the summons through the Ministry of Home Affairs. Because the person is found. They know his whereabouts. They say to this extent that they wanted to confirm and it was confirmed by email. That is their application. So that service is non-est, void. And Mr. Sibal said yesterday.
Yes.
So they want to do something, my lord, which is, we can't even in the eye of law, we cannot say that it is a notice. We cannot say that in the eye of law, it is a service. How can they proceed further? They cannot bypass, my lord, the procedure laid down under the statute like this.
Yes.
Now another point, my lord. My lord, the learned senior counsel, my lord, Mr. Sibal, yesterday, my lord, argued it, my lord, on the malice in law. And just supplementing with, my lord, and with another fact, which will may be very important for your lordship, my lord, is this. Your lordship may kindly note down, my lord, the two dates. The ECIR is recorded, my lord, on 6/10/2022. And, my lord, they get an information on 31/8/2023. Now, this is, my lord, almost 11 months. In these 11 months, in ECIR, they had already said that that is against me. The moment you record an SIR, the ECIR, you're investigating against me. For all these almost 11 months, my lord, they don't find it necessary that my statement is required. My statement is required under 50.
Yes.
On 31/8/23, my lord, they get an information that I am detained in Australia. The moment they get an information that I am detained in Australia, suddenly it comes into their mind that my statement is required now, on 1st. For 11 months, you don't think that my statement is required. Suppose, my lord, they had no information about me. I put it on another way. Suppose, my lord, they had no information about me on 31st. And it is another after 6 months, my lord. then they would have thought after 6 months that my statement is required. And immediately thereafter, they make an application for my arrest. So, what my learned friend, my Lord Mr. Sibal, senior advocate, said yesterday, malice in law. This was not at all a bona fide application.
Yes.
It is, my Lord, coupled with a malice in law. And therefore, the court will never act upon such an application.
Yes.
मैंने जो नोट बनाया था कल जो पीछे में ऐसे लिख दिया था I want to supplement on section 19 also. Section 19. Lord, there is a Lord power under the Code of Criminal Procedure, my Lord, to arrest. But the power under the Code of Criminal Procedure doesn't, my Lord, require these kind of, my Lord, thing that a reason is to be recorded in writing. That is not required under the Code of Criminal Procedure. But when the power of arrest is, my Lord, given under the special statute, it says that before arrest, you have to record reasons. Meaning thereby two things. One, the power to arrest in relation to a crime relating to PMLA is restricted than the power given under the Code of Criminal Procedure. In other words, it is limited. Because their requirement is not, but here there is a requirement. Pankaj Bansal, etc., even my Lord the Vijay Madan Lal Chaudhary, it says that before arrest, you have to record reasons. Without recording reasons, you cannot arrest. So in terms, it is restrictive in nature. Second thing, my Lord. The law is settled, my Lord. If an offense is registered, it is not necessary to arrest. Law doesn't say that as soon as the offense is registered or you are investigating the crime, you must arrest the accused. That is not the requirement. And if this is not the requirement, my Lord, then there is a test. Test for arrest. What is that test, my Lord? That if that person is not arrested, that either he will interfere in the investigation, he may influence the witnesses, he may conceal the material, he can interfere with that, or he is a flight risk. These are the tests. So there is a purpose for arrest. Having a power is a different thing and its exercise is a different thing. So when it says 19, for reasons to be recorded in writing, means that every investigating officer who wants to arrest, he has to record a reason. And those reasons can be like this only. Now the point is this, Willard. Twofold. What is their case? That we issued a summons under 50 that is not honored. Neither they have responded, neither they have appeared, nor they have responded. Can this be a ground for arrest? In my respectful submission, my lord, it can never be a ground for arrest. Because the ground of arrest would be, my lord, which is the test for arrest. The second thing is, my lord, this is the mandatory requirement that you will record the reasons. And we have taken this ground, my lord, in the petition, which is not replied, by saying that we have recorded the reasons. Maybe, my lord, your own ipsi dixi, court will consider it later. But where you have recorded the reasons? I have not responded to a summons. Question is different whether this can be a ground in the reasons.
Mr. Srivastava, the question herein is to jurisdiction of the court to issue warrant against the present petitioner.
Yes, I got your lordship's point, my lord. I was coming to that only. How it is related to arrest and how the 19 will
That
come.
is why. That is why.
How 19 will come.
Yes.
I was coming to that. I have not responded to, my lord, section 50 notice. It could not be in respect for, in my respectful submission, it could not be a ground for, it cannot be a reason as required under 19. But be that as it may, for the purpose of argument, take it as a...
Because whatever consideration the ED or the...
I'm just coming to, my lord, that. But because of this reason, my lord, you took a decision that I am to be arrested. The moment you take a decision that this person is to be recorded, the provision will come into play. Record reasons.
In the question herein, the manner in which the trial court has issued the warrant of arrest against you.
Another fact that what it is issuing, it is issuing a warrant for the arrest.
Yes.
If it is executed, then the person is arrested. Consequence is arrest. So once you frame in your mind,
it is not the fact that on the decision taken by the ED you have been arrested, or you may be arrested. It is the.
I am putting it different way, my lord. I am putting it differently. It is first, my lord, the decision of the ED. Court comes later. That because of this default, the ED has decided that this person is to be arrested. Thereafter, it makes an application before the court for the assistance that you issue a warrant of arrest.
The court should have decided their application independently on their own in accordance with law.
No, court will say, court will count in my respectful submission. When the court issues a warrant of arrest, then the court knows that if this warrant of arrest, effect of this warrant of arrest is only one, that the person will be arrested. So the person is arrested. He is arrested in relation to a crime under the PMLA Act. Therefore, 19 must be complied with. If reasons are not recorded, then the ED cannot ask for assistance. It is only assistance of the court for issuance of warrant. Court is not arresting for its own. It's not pending trial. It is two different things. Pending trial, for any lapse, the court will issue a warrant of arrest. But that is with regard to the court proceedings. But here the court is exactly, my lord, what is doing is giving assistance to the ED for a purpose of arrest. After when it is executed, then the ED will arrest it. He will be in the custody of ED. Subject to the formalities that he has to be produced before the magistrate and the remand, etc. But it will be arrested by the ED. So, movement, the ED says that we want to arrest with assistance or without assistance. They have to comply with the requirement.
Yes.
Only because they are seeking the assistance of the court, the requirement will not go. It will. And that's why, my lord, yesterday, Mr. Kapil Sibal, Learned Senior Counsel, rightly submitted that this was designed only to avoid all this.
Yes.
For 11 months, you don't think that his statement is necessary. His arrest is necessary.
Yes.
Now, my lord, there is a statement in the reply, my lord. And in my respectful submission, my lord, this nips the bud. Kindly come to paragraph 39 of their reply. The lordship knows, my lord, whether it is a petitioner or it is a respondent, nobody is, my lord, permitted to blow hot and cold in the same breath.
Para 39.
39. Not that when we find here that here is a difficulty, then we jump to the other side. We find that there is the difficulties there, then we jump to this side. That the contents of ground L are denied for being incorrect, as it is submitted that the NBW was requested only to ensure the petitioner's presence in investigation. The provision of section 19 of PMLA were not invoked, hence there were no requirement of recording of reasons to believe or putting the material before the Honorable Special. Now, two things again here. What is the statement, my lord? That my presence was required only for the purpose of investigation, not for the purpose of arrest. Very, very clear, in clear terms. So, if my presence was required only for the purpose of investigation, meaning thereby as a witness, then why you have asked for the arrest? You could have simply followed, meaning thereby, in other terms, you are not treating me as an accused at that stage. You are treating me as a witness. Therefore, no question of arrest. Since there is no question of arrest, no requirement under 19 to record reasons. So, if you are treating me only as a witness, then why don't you follow the procedure? What is the hurry? That on first you issue a summons for second you issue a summons for fourth is not expired, you make an application before the court and get an order on fourth, on urgent basis. As if the heaven is going to fall, if the order is not issued on fourth itself. And you have been investigating this matter for 11 months. 11 months you have not thought that my presence is required for the purpose of investigation. All of a sudden, heaven is going to fall if it is not done within a day. This goes, my lord, against that. Only on this ground, my lord, my petition must succeed.
Yes.
There is another reason, my lord. They cannot rely on section 50 summons to take an action of for seeking my lord warrant against me on the ground that I failed to answer section 50 summons. जो सवेरे निकाला था ना वो वाले दे दो एक पैराग्राफ, है ना, बहुत सारे जजमेंट्स की जरूरत है. Only for the I am arguing, my lord, for 2 minutes I am arguing in favor of the my lord from the ED side. Summons is issued. You fail to respond. Next thing, summons is issued to give evidence. According to ECIR, I am an accused. Before the session court, you are treating me to be an accused. Before your lordship, they are treating me as an accused. I have all the right to, my lord, ignore that summons. Number of judgments. It's my constitutional right. If you treat me like an accused, to remain silent. Kindly say, my lord, one judgment. There are a number of judgments. I will give the list. 2007, volume 12, SEC, page 230. Paragraph 95. There are a number of judgments, my lord. Supreme Court, almost seven, I will not say, my lord, every high court, but several following this proposition. And this, my right, flows from, my lord, the Constitution. And nothing can, my lord, override my right or protection, which is, my lord, guaranteed under the Constitution. This Article 20, 20 is, my lord, the part of the fundamental rights. Kindly see paragraph 95. Article 23 of the Constitution of India provides that no person accused of any offence shall be compelled to be a witness against himself. The right to remain silent is an extension of the rule of civil liberty enjoined by our Constitution. So what the Supreme Court, how the sentence is framed, my lord? The right to remain silent. I am just elaborating, my lord, just adding it. What would be the, my lord, meaning of right to remain silent? Right to remain silent would include that I will not give statement. And that is the old principle, my lord. Your lordship knows those judgments. That there are two cases going on, parallel proceedings. One is criminal and one is civil. The civil cases are stayed because saying that if we ask him to file a written statement here, that would amount to disclosing his defense. And he has a right to remain silent till the evidence is recorded in that matter. So all proceedings, civil proceedings state. So right to remain silent not only includes refusal to give evidence, right to remain silent, word uses silent, would include not to respond. This is how I am silent. Not to respond. So here we have to create two different classes. One class where you issue a summons under section 50 to a person who is only a witness. And the second class where you issue a summons asking him to be witness, but he is an accused. These are two different classes. But if a summons is issued to a person who is falling, my lord, in the second category, who is an accused, then this principle comes into play, that he has a right to remain silent. And if it is a constitutional right, then you cannot say that by remaining silent, he has violated the summons. And therefore, it can never be a ground in respect of an accused that you have not responded to section 50. Therefore, you are liable to be treated or you are liable to be proceeded. This can never be a ground. In fact, I wanted to argue something more, but I am not arguing because it would not be fair. Because Vijay Madan Lal Chaudhary has decided something which is against me, and so long as that is not reviewed. Otherwise, I would have gone to another aspect. Whether you can ask somebody who is an accused to give a statement. Then this has to be carved out. Your Lordship knows the theory of reading down. Even if the provision is not declared otherwise, it can be read down. Then the word which is used person in section 50, that has to be interpreted in a manner that person other than accused. Supreme Court and High Courts have done it at least 50 times, 100 times. That its exact meaning would be, an interpretation would be this. This will be carved out. We don't want to strike it down as a whole, but we carve out this and read it down to this. But that would be not be for your Lordship because the matter is already pending before Supreme Court. It would be absolutely unfair on my part to, my Lord, I am asking your Lordship to embark upon this. But my constitutional right is there. Now, my Lord, I go back to, my Lord, to that judgment on 73. The famous, my Lord, Dawood Ibrahim's case. And this is one of that judgment, my Lord, I would say that whenever it comes to the law, the court doesn't see this, that who is the accused, what kind of offense he has committed, what are the allegations against him. But if it requires, my Lord, to act under a particular law, then it must be complied with. Even in a case of Dawood Ibrahim, my Lord, was what the Supreme Court said. My compilation, page 12, my Lord.
Yes. Page 12.
Page 12 is the relevant, my Lord. It starts from page 1. But relevant, your Lordship will find in paragraph 21.
You are citing the 2000 volume 10.
Yes. This is 2000 volume 10 SEC 438. If Lordship comes to, my Lord, compilation, page 12, which is, my Lord, handwritten.
Yes.
Paragraph 21 and 22. That section 73 confers the power upon a magistrate to issue a warrant. And it can be exercised by him during investigation also. Can be best be understood with reference to section 155 of the code. As already noticed under this section, a police officer can investigate into a non-cognizable offense with the order of a magistrate and may exercise the same powers in respect of the investigation, which he may exercise in cognizable cases. Except that he cannot arrest without warrant. If, with the order of a magistrate, the police starts investigation into a non-cognizable and non-bailable offense, like section 466, 467, and if during investigation the investigating officer intends to arrest the person accused of an offense, he has to seek for and obtain a warrant of arrest from the magistrate. Pausing here for a moment, my Lord, one point is this, that 73 applies only in those cases where the investigation is under the authority of magistrate. Kindly read it again, my Lord. Except that he cannot arrest without warrant. If, with the order of a magistrate, the police starts investigation into a non-cognizable and non-bailable offense, and if during investigation the investigating officer intends to arrest the person accused of the offense, he has to seek for and obtain a warrant of arrest from the magistrate. Not where the police starts investigation by its own. if the accused evades arrest, the only course left open to the investigating officer to ensure his presence would be to ask the magistrate to invoke his powers under Section 73 and thereafter those relating to proclamation and attachment. If such an eventuality, the magistrate can legitimately exercise the powers under Section 73 for the persons to be apprehended is accused of a non-bailable offense, one, and is evading arrest. This is not their ground in the application. They say evading arrest. And that too, all of a sudden, when they come to know that I am there, they come to know that I am evading investigation. Then kindly see, my lord, next page. Paragraph 24.
24.
Yes. Now that we found that Section 73 of the Code of is of a general application and that in course of investigation a court can issue a warrant in exercise of power thereunder to apprehend inter alia a person who is accused of a non-bailable offense and is evading arrest. So both has to be present. Word and is, my lord, as time and again interpreted, it is conjunctive. Then last, my lord, 3 lines. I'm sorry, my lord. Evading arrest, we need answer the related question as to whether such issuance of warrant can be for his production before the police in aid of investigation. It cannot be gainsaid that a magistrate plays not infrequently a role during investigation in that on the prayer of the investigating agency, he holds a test identification parade, records confession of an accused or a statement of witness, or takes or witnesses taking into specimen handwriting, etc. However, in performing such a similar function, the magistrate does not exercise judicial discretion like while dealing with an accused of a non-bailable offense who is produced before the pursuant to a warrant arrest under Section 73. On such production, the court may either release him on bail under Section 439 or Section 467 of the Code. Whether the magistrate on being moved by the investigating agency will entertain its prayer for police custody will be at his sole discretion, which has to be judicially exercised in accordance with Section 167(3) of the Code. Since warrant is and can be issued for appearance before the court only and not before the police. Kindly underline this, my lord. Since the warrant can be issued for appearance before the court only and not before the police. So this is not an application, my lord, where my appearance before the court is trying to be secured. Not before, and since the authorization for detention in police custody is neither to be given as a matter of course, nor on, kindly underline this, blood, nor on mere asking of the police. This is exactly has been done in this case by the special court. But only after exercise of judicial discretion based on material placed before him, Mr. Desai was not absolutely right in his submission that warrant of arrest under Section 73 of the Code could be issued by the court solely for the production of the accused before the police in aid of investigation. That argument of the Mirror Attorney General has been repelled, that it can be for the purpose of production before the investigating agency. Now, another very important thing is there in this paragraph only. What the Supreme Court says. a warrant of arrest in 73 is issued, then what is the next step? Then he has to be produced before the magistrate. If he has to be produced before the magistrate, then my right is there, my lord, to apply for bail. Same paragraph says the court can release or court can give custody. Keeping this law in mind, can in the fact scenario of this case, 73 could be excised. Whether it is to be executed, let it be, my lord, part of we have already argued. Suppose, my lord, I take first scenario again. ED is given warrant, whether it can go and execute is a different matter. Let it be there. We take it like it goes and executes there. Now at that time he is in Australia. He arrests him in Australia. The law as well as his judgment. Within 24 hours he has to produce before the magistrate. Otherwise it becomes illegal. You have to release him. Can in Australia, my lord, he can produce before a magistrate. Second thing, when it is produced before the magistrate, then the magistrate has to exercise this power. He will consider whether he is to be kept in detention or he has to be released. Can it be done? So law is for every case different. So if the provision itself is not workable, why should it be invoked? This is my submission. Can't be done. And therefore the importance again comes into play is, my lord, that 59 of the PMLA Act that you move through Ministry of Home Affairs, because that is a separate provision and that court will execute it. Again, the purpose is this, the second purpose. Not only that court will apply its mind, then when that court is rooted through that court, then that court becomes for a limited purpose the court. Then maybe after arrest he can be produced before that court. But you cannot avoid it like this.
Yeah.
This compilation, my lord, I am not, my lord, just to save time. I have given all the judgments here and the relevant paragraph.
Yeah.
The point I have already argued. You would like to hear Mr. Hussain also.
Yes. Yes.
I am deeply obliged, my lord, for the patient hearing.
Thank you. Yes, Mr. Hussain.
May it please. Now, my lord, may please see. I have some preliminary objections before I deal with the submissions made by my learned friends. And even though my learned senior colleague was to only supplement the arguments of Mr. Sibal, but he has put forward weighty arguments in his own way, my lord, which I have to deal with, and I'm obliged to him for such wonderful arguments.
Yes.
Now, my lord, my first preliminary objection.
Yes, please.
My first preliminary objection is that the present petition is not even maintainable. My learned friends cannot even be permitted to put a foot in the door of this honorable court because of the consistent practice of courts across the country, as to how it deals with persons who are not joining investigation or not bringing themselves within the jurisdiction of the court. Please have my compilation.
Yeah.
If my learned friend can hand over my compilation, my lord. It says it is a compilation of 432 pages. It says compilation on behalf of the ED. I'm sure my learned colleagues
just
are.
a minute.
Yes, my lord.
With due apologies to my learned friend, Lord, they have just supplied, my lord, one document to us, which shows, my lord, there was one petition filed, my lord, at the Delhi High Court challenging RCN. RCN, na?
No, permit me to please now, Mr. I
No,
want to
I'm not
develop.
arguing it on. I'm not arguing
No,
on
but
it.
you can't disclose something once I have sent it to you. Please permit me to develop my arguments, sir. I never interjected
But
you.
if they're relying on this, my lord, then we have to respond to
Of
this.
course, you will.
Because
You'll
I'm
get
not
it.
aware about this.
You exactly what I want to say.
On this.
No, my learned senior is right, my lord. My learned senior has also not been instructed and apprised. Please see not only is there a suppression before the court, there is a suppression before my learned senior also. Because I've heard my learned senior's arguments. They are crisp, erudite, and very fair arguments. Had he been informed about this, he would have informed the court as the first thing that they have approached the Delhi High Court. But even my learned senior was kept in the dark. And I will point out, the pleadings are in the dark. My learned senior is kept in the dark. The court is kept in the dark. But that's my third submission. My first preliminary submission is, please see the judgments. First, before the judgment, please see the affidavit in the petition, my lord.
Yes.
And if this is the conduct of the applicants, petitioners, my lords have repeatedly held, the petition will be thrown out. That's the language of the courts, will be thrown out without even going into merits. Now, please see the affidavit, my lord.
Yes.
Please have page 39 in the Ravi Uppal petition and corresponding page. Both petition, my lord, may open at 39 in Ravi Uppal and 43 in Saurabh Chandrakar. The petition is sworn by a person other than the petitioner. The petition is sworn by a power of attorney holder. This is the undisputed fact. This is the undisputed position. Deepak Sharma is the power of attorney holder of Mr. Ravi Uppal, who has sworn the petition. And Mr. Khemraj Sinha is the power of attorney holder who has sworn the petition on behalf of Saurabh Chandrakar. Now, please see the law. Whether a petition where affidavit is sworn by a power of attorney holder seeking cancellation of NBW is maintainable at all or not. Please have, my lord, my first judgment at page 1. And consistent view, not of one court. I'm showing consistent view of Delhi. I'm showing consistent view of Punjab. And I'm showing consistent view of Kerala. At least 3 courts I'm showing. Please have page 1. My lord will see Justice Bhatnagar's judgment in Amrinder Singh versus State of NCT. Yes. Para 1, my lord will see what was under challenge was initiation of 82 proceeding was under challenge.
Yes.
My lord may see the 4th line. Proceedings initiated against the petitioner under 82-83 of the CRPC through his special power of attorney holder, Shri Sukhjinder Singh. Right, my lord? Now, please, para 6, the objection of the learned APP. It is vehemently argued by the learned APP that the present petition under Article 227, read with 482, is not maintainable as the same has been filed through a special power of attorney holder, and the present application and petition are liable to be dismissed.
Yes.
Now, please see the consideration of this aspect. In Amit Ahuja, para 7 onwards.
Yes.
In Amit Ahuja versus Gyan Prakash Bambari, it has been observed as under. The plain reading of the ratio laid down in the aforesaid cases clearly goes to reveal that it is only the accused person against whom a criminal case has been registered or a criminal case has been filed can file a petition under 482 in the High Court for quashing the complaint, the summoning order, and subsequent proceedings, and no third person can fight a proxy war on his behalf under the garb of PIL. The aggrieved party which is affected by an order is required to seek redress of its grievance by questioning the legal validity or correctness. It is another thing if the aggrieved party is suffering from some disability, unless he is a minor, insane, etc., is recognized as sufficient to permit any other person, next friend, etc., to move the court on his behalf. Next para, my lord, may see para 8. In T.C. Mathai, Section 2 of the Power of Attorney Act cannot override the specific provision of a statute which requires that a particular act should be done by a party in person. When the code requires appearance of an accused in a court, it is no compliance with. If it is a power of attorney holder appears for him, it is a different thing that a party can be permitted to appear through counsel. Then page over, my lord. Applying the ratio of these judgments, the court holds at para 9, and this is important for us. In the instant case as well, the petition has been filed through SPA holder, which is per se not maintainable. Therefore, no permission can be granted to the petitioner to file the present petition bearing criminal NC under Article 227 read with 482. So even a 482 petition seeking quashing of 82-83, please see, my lord, seeking quashing of FIR and charge sheet and all proceedings arising, including proceedings initiated under 82. 82-83 are coercive processes to secure a presence of a person through his SPA holder. Therefore, I find no ground to accept the prayer made in the present application. So the court does not even entertain the merits of the case. At the threshold, you filed through a power of attorney holder. You have not filed it directly as you're required in person, and therefore I will. Now, please consider why not in person. He does not want anybody to know where he is. Why not in person? Is there no corresponding provisions of notarizing? My lord is aware, even under the Notaries Act, Indian courts accept foreign apostilled notaries to be accepted as a manner of swearing on affidavits in India. Routinely, foreign notaries, notarized affidavits are being deposed in India. Despite that, this is not a technical defect. This is not a technical defect. It is a design. It is a design for the same reason when they say that you go and ask the contracting state. Which contracting state? Vanuatu is not a contracting state. Australia, he was a guest for one night. He says he's now in Dubai. Are we to keep guessing and then reach out to the contracting state? You commit. Now, the proceed of crime in this case, in this Mahadev betting app case, is upwards of 5,000 crore. We have traced around 567 crore only as on date, my lord. There is upward of 5,000 crore. Person who commits an offense in India, then absconds, leaves India, travels all over the country, says, you choose, you guess. Let's play a guessing game, which contracting state I am, and you keep initiating processes through those contracting states through your treaty. What kind of, my lord, process would that be? And, my lord, I will show the judgment of Mubarak Ali way back in the 1950s. I will place that judgment in some time. Settles the law that was a case of a Pakistani national sitting in Pakistan, committing offenses, committing cheating offenses in India. The court said it doesn't matter whether you are a foreign national. If you have committed an offense in India, you will be tried and punished in India. The laws of India, just because you're a foreign national does not mean it amounts to extraterritorial operation of laws of India. it is squarely within the competence of, and that is the famous judgment of Mubarak Ali. I will cite that in a minute, my lord. I'll just point out this was a 3-judge bench, Justice Jagannath Das's judgment, 1957. I'll cite that in a minute. It is not part of the compilation.
Yes.
So my first submission is petition not supported. Please see the index. My lord, I have put it in the index, my submission. A petition, the index of the compilation, my lord.
Yes.
A petition not supported by any affidavit or wakalatnama of the petitioner himself is not maintainable through a proxy power of attorney holder. Now I've shown Delhi. Please permit me to show Punjab now. Amit Ahuja at page 4, Mullah.
Yes.
Page 4, para 9. This was a challenge to the summoning order. If my lord will see page 4, the 482 petition was filed seeking quashing of the summoning order by the court in Patiala and all subsequent proceedings. Right, my lord? And it was filed through, not through the person, but through another person. And in that context, please see para 7 onwards. Para 5 is also important because that there also the person was in Dubai. Please see para 5. Despite being in Dubai, the court refused to accept that justification. The counsel for the petitioner submitted that, admittedly, Amit Ahuja petitioner, who is an accused in the aforesaid complaint, is residing in Dubai. She further submitted that in 482, there is no reference to person aggrieved. She further submitted that if there is an abuse of process of court, a person genuinely interested in the accused can file a petition. Under 482, she further submitted that since the complaint, the summoning order, and all subsequent proceedings are nothing but an abuse of process of court, Indu Ahuja, attorney of the petitioner, being genuinely interested in the matter, and locus standi and petition could be filed through her by the petitioner. So she says a power of attorney holder is a genuinely interested person. She can file a petition. She further submitted that almost all alleged offences were committed in Dubai. She further submitted that since cause of action arose within jurisdiction of courts at Dubai, complaint could not be filed in the courts in India. Same identical submission, my lord. Everything has happened abroad. You can't do anything in India. Article 245. Now please see. She further submitted that since complainant's summoning order and all subsequent orders are abuse of process, same is liable to be quashed. Para 6 is the submission of the other side. Counsel for the respondent submitted that petition under 482 by petitioner through his attorney is not maintainable. After giving my thoughtful consideration to the rival submissions raised by the counsel for the parties, in my considered opinion, the petition is liable to be dismissed. Punjab, I showed Delhi, now I'm showing Punjab. Petition is liable to be dismissed being not maintainable for the reasons recorded hereinafter. Admittedly, the aforesaid complaint was filed against the petitioner and his co-petitioners in courts at India. There is no dispute about the factum that Amit Ahuja is residing in Dubai. There is no dispute today that Ravi Uppal and Chandrakar are not in India. Same identical facts. Now please see, my lord. Page over at para 9. After recording some judgments, the court gives its reasoning. The plain reading of the ratio of law laid down in the aforesaid cases clearly goes to reveal that it is only the accused person, a lot may mark this, only the accused person against whom a criminal case is registered or a criminal complaint filed can file a petition under 482 in the High Court for quashing the summoning order and subsequent, and no third person can file a proxy war on his behalf under the garb of PIL. The aggrieved party which is affected by an order is required to seek redress of its grievance by questioning the validity or correctness of the same. It is another thing if the aggrieved party is suffering from some disability, like a minor, insane person, etc. Next friend can move the court. on behalf of minor or insane, a guardian or next parent initiates the proceedings. Then, my lord may see 2-3 lines below. In the instant case, there is nothing on record that Amit Ahuja petitioner is suffering from any disability. Please mark this. This is important. In the present case also, my lord, our case, nothing on record to show why is he disabled from filing his own affidavit before the court. Suffering from any disability recognized by the provisions of law. He is an accused in the aforesaid complaint. It is he who is aggrieved against the complaint and the summoning order. It is he who can challenge the same on any ground which may be available to him under the provisions of law. If in criminal cases, until and unless a person is allowed to fight the proxy war, then the very purpose of criminal justice system shall be defeated. In the event the courts would be mushroomed by PILs in this view of the matter, present petition under 482 filed by the petitioner through his attorney, my lord, mark this, through his attorney is not maintainable. On this ground alone, the same is liable to be dismissed. Next para also, my lord, will see. The counsel for the petitioner, however, placed reliance on Ravi Gupta, Gurmeet Kaur, Kuldeep Kaur by this court in support of a contention that the petition under 482 is maintainable through attorney. In Ravi Gupta's case, the question fell for consideration whether a complaint under 138 could be filed by the complainant through a power of attorney. The Delhi High Court held that the complaint could be filed through a power of attorney after obtaining the leave of the court for pursuing the same through a power of attorney. In Gurmeet Kaur's case, a petition under 482 for quashing criminal proceedings could be filed through an attorney. Reliance therein was placed on Ravulu to bar out. The careful perusal of facts of Ravulu clearly goes to show that the question before their lordships in the apex court that fell for determination was regard to interpretation of Section 2 of Power of Attorneys Act. In Ravulu, no question fell for decision before the apex court whether an accused could file a petition under 482 for quashing criminal proceeding through an attorney. Not only this, even the co-accused of Gurmeet Kaur in Gurmeet Kaur had already been acquitted of as against her co-accused who were acquitted. After trial, no useful purpose shall be served by keeping criminal proceedings alive, and as such, the same were quashed. In Kuldeep Kaur, no question fell for decision before a single bench of this court as to whether a petition could be filed by an accused through an attorney. So all those judgments, my lord, were distinguished. And para 11, my lord, see. For the reasons recorded above, criminal miscellaneous case not maintainable through attorney stands dismissed. Right, my lord? Now, please see Supreme Court in TC Mathai. Page over, my lord. TC Mathai, my lord. Para 2, my lord, will see for the facts. The appellant claims to be the power of attorney holder, and this I am citing Supreme Court. Justice K.T. Thomas at page 12. The appellant claims to be the power of attorney holder of a couple, husband and wife, now living in Kuwait. He sought permission of the Sessions Court Trivandrum to appear and plead on behalf of the said couple who are arrayed as respondents in a criminal revision petition filed before the said Sessions Court. They will be referred to as the respondent couple. But the Sessions Judge declined to grant permission as the request for such permission did not emanate from the respondent couple themselves. Thereupon, the appellant moved the High Court under 226 for issuance of a direction to the Sessions Judge concerned to grant the permission sought for. A single judge dismissed the original petition against the appellant, who filed a writ appeal, which too was dismissed. Undeterred by the setback in securing a right of audience on behalf of the aforesaid couple, appellant travelled a long distance from the southern end of the country right up to the national capital. My lord, Justice Thomas was known for his wit, my lord, which is reflected in his judgments. Capital to personally argue before the apex court that he is entitled to plead for the respondent couple in the Sessions Court. We heard the appellant in person, though we are still unable now to appreciate why he, instead of incurring so much expense and strain, did not advise the respondent couple to engage a counsel for pleading their cause before the Sessions Court. Now, in that context, please see para 15.
Yes.
Section 2 of the Power of Attorney Act cannot override the specific provision of statute which requires that a particular act should be done by a party in person. When the court requires the appearance of an accused in a court, it is no compliance with it if a power of attorney holder appears for him. It is a different thing that a party can be permitted to appear through counsel. Chapter 716 of the Code empowers magistrate to issue summons or warrant for appearance of the accused. Section 205 empowers the magistrate to dispense with personal attendance and permit him to appear through his pleader. So the same logic will apply even for a petition. He has to at least file his own affidavit. How else do we know, my lord, that what he is swearing on is to his own knowledge? My lord will be aware that in the affidavit, when a person swears, as per the CPC, my lord, the swearing of affidavits, he has to say these facts are known to me as per my own knowledge and to the best of my belief. So it can't be the belief and knowledge of the power of attorney holder. We don't know if any of these facts that he's swearing upon are correct or not. And these are not just technical pleas. I will show judgments of the Honorable Supreme Court where, my lord, the incorrect affidavits has been the basis of rejecting the whole petition by relying on the relevant order in the CPC. That is Order 13, if I'm not mistaken, my lord, Order 13, Rule 2. Now, please see, my lord, because these are vital, these are contested factual issues where parties cannot, my lord, be permitted to resile from their statements that they say on oath because there are consequential proceedings. Today, my lords don't even have an affidavit of the concerned person. Now, in that context, please see, my lord, read further. Section 273 of the Code speaks of the powers of the court to record evidence in the presence of the pleader of the accused in case when personal attendance of the accused is dispensed with, but in no case can the appearance of an accused be made through a power of attorney holder. In no case can appearance be made through a power of attorney holder. So the contention of the appellant based on the instrument of power of attorney is of no avail in this case. This is the Supreme Court relying upon, my lord, a full bench in M of Madras High Court, which is recorded next para. Please see para 16. In this context, reference can be made to a decision rendered by a full bench of the Madras High Court in M. Krishnammal versus T. Balasubramaniam Pillai, when a person who was the power of attorney holder of another claimed right of audience in the High Court on behalf of his principal. That is exactly what is sought to be done today in this case. A power of attorney holder is claiming a right of audience before my lord, the High Court, in this case. A single judge referred 3 questions to be considered by the full bench, one of which is relevant, was whether an agent with the power of an attorney to appear and conduct judicial proceedings has the right of audience in court. Chief Justice Beasley, who delivered the judgment on behalf of the full bench, stated the legal position. An agent with the power of attorney to appear and conduct judicial proceedings, but who has not been so authorized by the High Court, has no right of audience on behalf of the principal, either in the appellate or original side of the High Court. There is no warrant whatever for putting a power of attorney given to a recognized agent to conduct proceedings in court in the same category as a wakalat given to a legal practitioner. Even the wakalat, please see who signs the wakalat in this case. Though the latter may be described as power of attorney, which is confined only to pleaders, those who have a right to plead in courts. The aforesaid observation, though stated 60 years ago, would represent the correct legal position even now. Be that as it may, an agent cannot become a pleader for the party in criminal proceedings unless the party secures permission from the court to appoint him to act in such proceedings. The respondent couple have not even moved for such a permission, and hence no occasion has arisen so far to conduct that aspect. Now, please see the wakalat also, my lord, in this case. There's no wakalat. I don't know if my lord's file has a wakalat. My file doesn't, but the affidavit is sworn by the power of attorney holder.
No, in the present case, the memo of appearance is there. It is only a declaration that I have been authorized by such and such person.
That's right. That's right.
And Wakalatnama is something different than Wakalatnama is a declaration by the party that I have authorizing this person to plead on my behalf.
Which is missing in this case.
Yes. No. Here the practice is the memo of appearance is required.
I agree.
As per the High Court in criminal matters, the memo of appearance is required.
I agree. But
declaration by the council that I have been authorized by such and such person.
Right.
Yes, but please see the affidavit, my lord. The affidavit to which the party has sworn the facts. Please see the affidavit, my lord, for a moment.
Yes.
Page 39 of Ravi Uppal's case. Please see the affidavit.
Yes.
And my lord, may please see the verification at the end.
Yes.
I, Deepak Sharma, the above deponent, do hereby verify that the contents of the above affidavit are true to the best of my personal knowledge. This is a false affidavit. It's a completely false affidavit. It can't be true to his personal knowledge. Please see the averments. Who is Deepak Sharma? And belief signed and verified at Bilaspur. First point, that a power of attorney holder cannot maintain a petition under the code under 482 seeking quashing of an order passed by the concerned court. A power of, that's the settled law. Number two, even the affidavit is faulty and completely false, and therefore on that ground also the petition has to be rejected. Now please see, my lord, please have the CPC for a moment.
Yes.
Yes, ma'am. Please have, my lord. In the CPC, the relevant provision, my lord.
Order 615, the verification of the pleadings.
No, I'll just point out, my lord. Just give me 1 minute. Just 1 second. Lord, may I have? Order 19.
Yes.
Order 19, my lord, has Rule 3. Matters to which affidavits shall be confined. Affidavits shall be confined to such facts
Rule, what is the rule?
Order 19, Rule 3, my lord. Matters to which affidavits shall be confined.
Yes.
Affidavits shall be confined to such facts as the deponent is able of his own knowledge to prove. Please mark this expression, my lord, own knowledge. And I will show series of pleadings in this case where there is no effort to demonstrate how either Mr. Deepak or Mr. Khemraj, who are the deponents in the affidavit, would ever have their own knowledge to prove this. And violation of this, my lord, may only note one citation. My learned friends may not have it in court. 1969, 3 SCC, 1969, 3 SCC, 864. And I'll have it sent to my lord's chambers by the end of the day. AK Nambiar versus Union of India. My lord may note the para 8. And I will just read a sentence from there, my lord.
Yeah.
Allegation. The reason for verification of affidavits are to enable the court to find out which facts can be said to be proved on affidavit evidence of rival parties. Allegations may be true to the knowledge or allegations may be true to information. The importance of verification is to test the genuineness and authenticity of allegation and to make the deponent responsible for allegation. In essence, verification is required to enable the court to find out as to whether it will be safe to act on such affidavit evidence. In the present case, affidavit of all parties suffers from mischief of lack of proper verification, with the result that the affidavit should not be admissible in evidence. Now, if this affidavit itself is in violation of Order 19, Rule 3, then all facts in support of which this affidavit is filed have to be completely ignored, which includes the entire petition. Now, my lord, this was my first submission. Insofar as, please have one more preliminary objection.
Yes.
This was my first preliminary objection, that a petition supported by an affidavit of a power of attorney holder is not maintainable at all. They don't deserve a foot in the door. And on this ground alone, my lords have seen 3 courts dismiss the petition under 482. My lord may have, and if my learned friend in court can hand over, the Delhi High Court in Ashok Malik versus Soga Impex. This could not be made part of the compilation. Yes. So it's a short, very short 3-page judgment. This is the second preliminary objection. Ashok Malik versus Soga Impex, Delhi High Court.
Yes.
Para 9, my lord, Mr. The second preliminary objection is a warrant cannot be cancelled in absentia. Para 9. First of all, warrants cannot be cancelled in absentia. So a person will have to present himself at least before this honorable court for the warrant to be cancelled and for the petition to be entertained. Out of fairness, I must point out that the Bombay High Court has a slightly different view. What I'm showing is the Delhi view, my lord. And I would urge, my lords, in a case of this nature, where a person is clearly evading the process of law. And why do I say that? A person takes the citizenship of a country of Vanuatu. When does he take that, my lord? He takes it in June 2022. when he knows that the criminal proceedings, like in the scheduled offences, etc., are heating up, they're on the heels, he takes up, my lord, the citizenship of a country with which India has no extradition treaty, no contractual arrangements. The only and only reasonable presumption would be that he wants to evade the process of law, having cheated large number of innocent persons through gambling app and generated thousands of crore. 5,000 crore is estimate as on today, my lord. And daily it is being misused. That is the estimate as on today. So and then the argument taken is Article 245, that India can't do anything. The hands of the criminal law is limited to its jurisdiction is the argument taken. And my lords are exercising extraordinary jurisdiction under 482. It's a vital consideration to be taken into account whether a person of this nature files a petition not through his own affidavit, through a power of attorney holder, does not present himself. Would my lords even entertain such a petition in exercise of its extraordinary powers under 482? Extraordinary inherent powers. Now please see para 9 of Ashok Malik.
Yes.
And please see the facts in para 8, my lord, it will resonate. In the instant case, the petitioner had travelled beyond the jurisdiction of India. Beyond the jurisdiction of India without seeking permission of the court. Normally speaking, if the petitioner wanted to travel abroad, he ought to have obtained the permission from the court for undertaking such a travel. On 2nd March 2012, neither the accused nor his counsel was present. Consequently, after waiting for them till lunch, the court had no option but to issue non-bailable warrants. The petitioner is purported to have filed application under 70 for cancellation of warrant. Various grounds for cancellation have been given, including an application seeking extension of visa to travel to India. Now, my lord, may put to him, let us keep aside everything. Let us keep aside the warrant. If my lord will recall, the first offer and suggestion I had given was to enable him to come to India and join the trial. Please put to them, my lord, will you ever join the trial? Because today the prosecution complaint stands filed. They've been made accused and the court has issued summons. Will they ever join trial, my lord? The answer is no.
Yes.
It is resounding no. Because if, my lord, if there was any genuine person who wanted to come to India, avoid coercive process and join trial, they would have jumped at that offer, my lord. That yes, because in that Sumit Chadha order that I showed, my lord, of the Delhi High Court, the court made that suggestion. I agreed. I said, all right, fine, let him come. Let him, if he comes, you cancel the NBW. Please put to them that offer, my lord. Are you willing to come? If they are not, then that shows their conduct, that they never want to come to India and submit to the jurisdiction of the criminal processes in India. Today, they can't have a trial even prior to joining the trial, my lord.
Yes.
I assure, my lord, they will never agree to this suggestion. And I'm saying this with some responsibility, my lord. Put to them that, and I, on a concession by me, my lord, may say, NBW will be suspended if you come, and if you join the trial, it will be cancelled. What more? That's what they're here for. Today, the prayer is not to quash the summons, my lord.
All the purpose to issue NBW is to secure presence of the person.
That's right. To secure presence. And if a person is willing to join the trial, a person who's bona fide would want to say that please don't arrest me. If I reach India because of the NBW, you will arrest me. You will put me behind bars. Therefore, please cancel the NBW. I will come and join. That is generally what people say.
Yes.
Now, in that context, para 9, first of all, warrants cannot be cancelled in absentia. For this purpose, accused has to appear before the court concerned. So this is my second submission. Now, my lord, a host of arguments have been made insofar as, because there is some legally inconsistent arguments also between my learned senior counsels, but I will presume it that they're taken in the alternative. Mr. Sibbal's cases,
Yes.
but I'm sorry, I'm just a little conscious that whether I'm eating into my lord's lunchtime.
No, it will. The more time is there.
All right, very well, my lord. Because in Delhi, the courts rise at 1:15.
Here 1:30 is the lunchtime.
1:30. Very well, my lord. Now, my lord, broadly, as I've understood my learned friend's arguments,
Yes.
I'm quickly summarizing what Mr. Sibbal and what my learned friend have argued.
Yes.
Mr. Sibbal's case is that when there is a 50 violation, suppose you issue me a summons under 50 and I do not appear, your recourse is limited to 63(2). That is a civil penalty. That was his first submission, my lord will recall. You cannot take the aid of the CRPC because PMLA is a special law and invoke 70 and 73. That's his argument. That's his first argument. The second argument was Section 59 is a special provision if you have to serve summons to another contracting state. 59 of PMLA. Third submission was that Section 70 of CRPC cannot be a repository of the power of arrest. That has to be done in terms of 19, which is where there is some overlap with my other seniors' submissions. Fourth was, my lord, you can't proceed against a foreigner except in accordance with the MHA circular, and that too through the court. Fifth submission, my lord. Now the submission of my learned senior, which he made today, is that you have to go by 105(b)(2) because that is not done. Therefore, the entire process is illegal. He also relied on the MHA circular to show that it takes 12 weeks time to serve, etc. The application doesn't use the word evading arrest, which is a prerequisite under 73. The prayer in the application is itself contradictory. How can you execute summons outside of India? How can you execute a warrant outside India? Therefore, your prayer is incorrect. Then, my lord, relying on 63, service of summons should be in person. The fact that 11 months after ECIR, no summons have been issued demonstrates malice. There is no satisfaction under Section 19, and therefore there cannot be any evading of arrest when you've not formulated any reason to believe. And that the court has mechanically passed the order without even examining if the arrest is necessary. Broadly, and that the right to silence includes right to remain silent. And this is, my lord, the most delicious argument, that the right to remain silent includes not to respond to the summons. It's ingenuous and delicious at the same time, and I'll deal with it. So broadly, these are the submissions that I'll have to cover here.
Yes.
Now, my lord, first submission that my learned senior, Mr. Sibbal, had made is that you cannot, in a PMLA case, resort to Section 70 and 73. Before I come to other judgments, please have a judgment of the Punjab and Haryana High Court Division Bench upholding issuance of an NBW in a PMLA case, which judgment is subsequently upheld by the Supreme Court. Direct judgment of Sikandar Singh, and that NBW was also issued. My lord, my learned friend will have to hand it over because these judgments developed after the arguments developed of the other side. So it will not be in the ready-made compilation. Sikandar Singh and Dharam Singh will have to be handed over. These are individual judgments. Dharam Singh is a one-page order of Supreme Court, and Sikandar Singh is the DB, Division Bench of Punjab and Haryana High Court.
Yes.
Now, my lord, has the Division Bench of Punjab and Haryana High Court, Sikandar Singh and Dharam Singh. There are two petitions, my lord may note, Sikandar Singh and Dharam Singh at the top. Dharam Singh had travelled to Supreme Court against this order, against this judgment, and Supreme Court had confirmed it. After arguments, it was dismissed, my lord. The SLP was dismissed as withdrawn.
It was withdrawn. The SLP was withdrawn.
Yes, after many days of arguments, it was withdrawn. I'll place the entire order sheet. I'll place that. But nevertheless, it was dismissed as withdrawn. And, my lord, the observations of the division bench in their case, because their bail, etc., was pending, the court said will not be treated as finding on merits. Because there were other observations on allegations as well. But please see the division bench judgment at para 14. Para 14 is at page 32.
Yes.
The third argument that non-bailable warrants could not have been issued in aid of investigation is also devoid of merit. Firstly, it has come on record that the petitioners had not been cooperating with the respondents, and that while they initially appeared in pursuance to the notices issued, they gave evasive answers, and now they have not been appearing in pursuant to summons or notices issued by the respondent. If this argument was to be accepted, an investigating agency, be it the jurisdictional police, the ED, the CBI, or any other agency, would have no remedy if an accused chose not to cooperate with the investigation. It cannot be accepted that an investigating agency would be rendered without any remedy. Even otherwise, it is well settled that an accused can very well be summoned or his presence can be compelled by way of non-bailable warrants by the court at the instance of the investigating agency. The only safeguard that has been laid down is that after the NBWs are executed, the accused cannot be produced before the investigating agency, but he has to be produced before the court, which shall thereafter proceed in accordance with law. The judgments relied upon by the counsel for petitioners and also by counsel representing respondent precisely lay down this very proposition. So, my lord, this is in response to the submission that under PMLA, for PMLA investigation, you cannot resort to section 70 and 73 of CRPC. That was precisely what was done in Sikandar Singh, and the Punjab and Haryana High Court proceeded to rely upon Dawood Ibrahim and held in aid of investigation, investigating agency can do so. Now, please see para 14.3. In the case of State versus Dawood Ibrahim, CBI moved an application before the designated court praying for issuance of warrant of arrest against the accused to initiate further proceedings in the matter to apprehend them and or to take further action to declare them as proclaimed offenders. These applications came to be rejected by the designated court. It was held by the designated court that there was no provision which entitled the investigating agency to seek for and obtain aid from the court for the same. It was held that presence could be compelled only to face trial, but no process could be issued in aid of investigation under 73. The matter reached the Apex Court. After examining the matter, the Apex Court held that Section 73 gave the power to a magistrate to issue warrants of arrest, and that too during investigation. Reference was made to Section 73 and Section 155 CRPC. Apex Court then examined as to whether such issuance of warrant could be for production of such a person before the police in aid of investigation. This, the Honorable Apex Court held, could not be done, and it was held that the warrants could be issued for appearance before the court only, and thereafter it was for the court to decide as to whether detention is to be given or not. The relevant observations and findings of the apex court in the said judgment are as under. The moot question, therefore, that now requires to be answered is whether the court can issue a warrant during investigation for his production before police in aid of investigating agency. And then, my lord, will see next page, para 22, which is an extract of Dawood Ibrahim, that section 73 confers a power upon a magistrate to issue a warrant, and that it can be exercised by him during investigation also. During investigation also can be best understood with reference to 155 of the code. As already noticed under this section, police officer can investigate into a non-cognizable offence with the order of a magistrate and may exercise the same powers in respect of investigation which he may exercise in a cognizable case, except that he cannot arrest without warrant. If the order of a magistrate, the police starts investigation into a non-cognizable and bailable offence, and if during investigation IO intends to arrest the person, he has to seek for and obtain a warrant from the magistrate. So in a non-cognizable case, he will have to seek warrant from magistrate, but in cognizable case, my lord, the police will have independent powers. Then, my lord, will see next page. Next page, my lord, at page 37, internal page 37, para 14.4. The court relies on, this view was reiterated by the Delhi High Court in Ottavio Quattrochi. Relying upon the judgment of the apex court in Dawood Ibrahim, it was held by the Delhi High Court that special court was justified and within his jurisdiction in having issued non-bailable warrants of arrest during course of investigation. In the present case also, no fault can be found with the order dated 29/9, which has been impugned by the petitioners and by way of which NBWs were ordered to be issued. The order is well-reasoned, speaking order, and it nowhere directs production of the petitioners before the IO. It goes without saying that once warrants are executed, the respondent would be bound by the provisions of law, be that PMLA or CRPC. The other judgments are of no aid. Therefore, when a court issues an NBW under 73, we are required to execute it, present him before the court, and thereafter we can rely upon PMLA and exercise our powers. So if we want to arrest him under 19, we would exercise 19 thereafter, my lord. Now, the Supreme Court, long back in a judgment, had recognized that there can be two kinds of arrest. I'll place that judgment. Two kinds of arrest. The first, where the court issues a warrant, and in execution of that warrant, you arrest a person. The other is where the executive or the agency arrests, exercising statutory power. What is today, my lord is concerned with is the warrant of arrest issued by a court. We have not exercised a power under 19. It is the warrant issued by a court. And my learned friends are conflating the two. The Supreme Court, in a 5-judge bench, constitution bench, recognizes there can be two kinds of arrest.
Yes.
I'll place that judgment in a minute. So, Sikandar Singh, the reliance was for the purpose of showing that 73 of the code can be relied upon by an investigating agency like ED, despite the PMLA, because there is no such inconsistent provision in PMLA. Please see section 65 of PMLA for a second. Section 65 of PMLA says, provisions of CRPC to apply unless there is anything inconsistent in PMLA to that effect. There is no such provision like 70 or 73 in PMLA, my lord. Please see 65. The provisions of the CRPC shall apply insofar as they are not inconsistent with the provisions of this Act to arrest, search, seizure, attachment, confiscation, investigation, prosecution, and all other proceedings under this Act. Now, please see the definition of investigation in 2NA. 2NA defines investigation to include all proceedings under this Act. Investigation includes all proceedings under this Act. Correct, my lord?
Yes.
Therefore, 65 says CRPC will apply insofar as they are not inconsistent with provisions of this Act in relation to all proceedings under this Act. Now, my lord, there is nothing inconsistent between 73 and PMLA. 73 of CRPC is a power coupled with duty given to the agency to approach the court and have an NBW issued in aid of investigation, as laid down in Dawood Ibrahim Kaskar, as laid down in Sikandar, as laid down in Otavio Potrochi. So therefore, the provision of 73 correctly invoked, because there is nothing inconsistent in PMLA. That is insofar as whether we could have resorted to CRPC is concerned. Now, please see 63(2). Merely because a consequence of violation of 50 is provided does not mean I cannot resort to provisions available to me to secure his presence. 63(2) has nothing to do with securing his presence. 63(2) is only a penalty for non-compliance with 50. Please see, my lord, 500 rupees, which may extend to 10,000 rupees. It's a penalty. It doesn't say that you can't exercise any other power but this. Doesn't say so anywhere. So 63 has to be harmonious. It does not say, notwithstanding 65, 63 is the only thing that will apply. Please see the effect of what Mr. Sibal has argued. The effect of what he argues is to add words to 63, my lord, which is not there. He wants to read 63 to say, notwithstanding anything contained in CRPC or section 65 of PMLA, you can only impose penalty and not resort to powers where you can secure his presence. That is absent here. If my lords were to read it the way Mr. Sibal wants my lord to read it, it would amount to reading words into 63, which is missing. He says 63(2) is the only penalty. Therefore, you can't rely upon 73. That is not flowing from 63(2) at all, my lord.
Yes. We continue after lunch.
My lord, may I? There is one matter which is overnight part heard, my lord, in Punjab in regard, and that is a liberty matter, where a person, my lord, he's a Congress MLA who has been taken in prison, and he is seeking to be released because of recent Haryana election. I am on my leg, my lord. I had thought, my lord, I will be able to complete this matter in the morning session, but of course, my lord, we all had the benefit of my learned seniors' arguments. So can I continue, my lord, tomorrow, if it suits my lord's board?
Tomorrow, probably Mr. Srivastava would not be here.
Then, my lord, can it be any day of my lord's choice which Mr. Srivastava is there? Any day of my lord's choosing. Had it not been a liberty matter, my lord, I would have...
Just a minute, let Mr. Srivastava convenience to be seen.
Monday?
Just a minute.
Let us continue tomorrow.
Tomorrow.
Only difficulty is he has to go back. But
he can join on VC.
Mr. Srivastav, does it suit you on Monday, sir?
The holiday here. Monday is the holiday.
Monday is the holiday. Very good. Tomorrow then.
In a full bench, and that matter will take time. And it's always better to finish the matter.
We'll finish it tomorrow.
It is not something that we are missing many.
That's true. That's true.
Let us continue tomorrow.
Very good. And my lord, I must confess, I really enjoyed listening to Mr. Srivastav. It was a pleasure, my lord.
So, it is our understanding that it will be taken tomorrow.
Tomorrow. Deeply obliged.
Thank you. We will try. Subject to the fresh matters list. Because क्योंकि फ्राइडे है, फ्राइडे को थोड़ी सी बेंचेस डिस्टर्ब रहती हैं वो.
That's true, my lord. That's true. In all courts, that's the problem. My lord is right. In all courts.
We will try our level best to finish it by tomorrow.
Yes. My lord, may only note that arguments were partly heard by us also.
Yes, yes.
Deeply.
Otherwise, this matter will come before last. All matters related to that ECI.
No, Mr. Srivastav, I have a different reason to request that.
Sure.
Because as government counsel, I don't know if you've ever had government briefs. It's a different reason why we say that. I think my lord is aware.
Yes.
Yes.
But tomorrow, it will be taken to.
Deeply obliged.